This and subsequently upon disclosure of further details. What nonsense is it? Records are with you. You are privileged with the record and you want me to produce it. Is that the law of evidence says? The answering respondent has no knowledge about the alleged different statements given by his previous president and accordingly refrain from making any comments thereon. Such refraining, it is made abundantly clear, is not an admission of the statements. The answering respondents further say that the petitioner failed to establish that there has been any pick and choose between the candidates. I have given 2-3 examples. You could have come up saying that his marks is X. We have given appointment to Y. Y is higher than X. And now there are 100 petitions pending before this court. To summarize everything, I have just prepared without the chart of rank jumping. I shall hand over to it, Your Lordship. This is the affidavit in detail by the board. Kindly come to the paragraph 19. The specific pleadings in the writ petition when they were touched. It is stated that by the order 396, paragraph 19. It is stated by the order dated 20th December 2022, this Honorable Court directed the answering respondents to come up with the particulars in tabular form. The marks obtained by last empanel candidates of different categories and different mediums of all districts. In compliance thereof, the answering respondents with a memo dated so and so submitted the list of petitioners along with the breakup of total score together with the breakup of total score of the last empanel candidates in the respective medium, category and district wise. The said direction was furnished in a tabular format before the Honorable Court. Such report is annexed. It is then, my Lord, if upon examining the said tabular chart, further queries are required to be addressed, the answering respondents are willing to explain them. Is it not withholding? The court will direct, then only you come up with your defense. The answering respondents categorically deny that the report is absolutely bogus as alleged at all. It is clarified that if at any stage of the selection any ineligibility is detected by the examining body, then the candidature of the applicant can be rejected at any point of time. It is not a correct appreciation of the position of law that if at the time of scrutiny or verification a candidate clears his scrutiny verification, he or she cannot be declared as ineligible before or even after being recommended. In other words, if a candidate upon crossing the hurdle of scrutiny and verification is permitted to sit in the interview aptitude test, the right of the examining and recommending body to recheck, revisit the candidate eligibility is not wiped out. Any allegation against such a contention is emphatically denied. Furthermore, a candidate is rejected, the examining body is obliged to inform him the reasons, see the audacity. The reason of such rejection under the applicable statutory rules. It is categorically denied that the report filed by the examining body is absolutely bogus as alleged at all. It is further denied that the report is absolutely false as alleged at all. Well, the denial is that it's not absolutely false, partially false. The Deputy Secretary of the answering respondents complied with the order of this court. Then, my Lord, will kindly come to paragraph 20. I say that not in respect of one candidate, Noor Huda Khan. In the present proceeding, where the prayer is for treating the petitioners equally with recommended non-trained candidates, the issue may not be gone into. However, if this Honorable Court passes a direction, the alleged ambiguity pertaining to Nur Huda Khan can again be looked into by the answering respondents. It is categorically denied that intentionally marks of the petitioners were reduced while submitting the report of before this Honorable Court. Certain RTI query answers are cited to demonstrate that the incorrect report was submitted. Such RTI answers keep to be thoroughly scrutinized if necessary before arriving at any conclusion. But does it not show that the authority was trying to evade the responsibility? But these are the pleadings. And if your Lordship really goes by this pleading, what is the outcome of it? Outcome is there has been allegations by a candidate of gross irregularities, corruption, fraud, and the authorities filing affidavit says we are answerable only when the court asks to answer, not otherwise. নোটিফিকেশনটা কবে হয়েছিল? একটা কথা রুটসটা না রিক্রুটমেন্ট নোটিফিকেশনটা এই রিক্রুটমেন্ট ডেট কবে জানো? 26শে সেপ্টেম্বর 2016। নাকি Now, my lord, will kindly take the trouble to come to the recruitment notification at page 120.
Pertaining this candidate why an explanation was given, which was submitted to police. Ask your junior just to recollect. We have taken that on record. Then what is your why was it was so far as I remember candidate why the name was not given. Subsequently document was by Mr. Sen.
My lord, the full name was not given by the candidate.
This was a vote of their parties. So please,
The full number was there.
yes.
I shall see their reply. Kindly turn to recruitment notification at page 120. The copies you may need a microscope, but
ওদেরকে দিয়েছে।
I'm just reading out, Lordship may. This was dated 27th of September 2016. Date is important.
Page 120.
Does the Mr. got it? I have a better copy. Oh.
Yes.
Can you note the date, nothing else? 27 September 2016. 26. Anyway, I am not able to read it.
Yes.
And this notification was issued on 26 September 2016. And let us see what was the relaxation given by the NCT for non-trained.
Page 95.
Kindly turn to page 95. ফিলিং থেকে দাও। সাগরটা দিয়েছে কি দিয়েছে দরকার নেই। Yes.
Relaxation was extended, Mr. Bhatt.
I'll come to that. On that date, there was no relaxation.
On
26th of 2016, there was no relaxation. Relaxation came to an end. Kindly come to page 95.
Yes. Page 95, yes.
Yes.
Relaxation up to 31st March 2016.
Yes.
Yes, subject.
Yes. Relaxation was up to 31st March 2016. Therefore, on the date of notification, recruitment notification, the relaxation was over. Therefore, no one who was not qualified on that date could have got the benefit of relaxation. Now, I will come subsequent amendment. Therefore, on 26th of September, the relaxation granted on 9th of April 2015 had no force.
Provides of course.
Yes. That's our point, I argue.
That has not been the case in the petition.
I would again say, Milord, this
was never a point in the case.
It's a pure question of law.
Government trusted me. We took note of that submission. But you say, what is it? In the writ petition, the argument which you are making is not there.
Yes.
There was no.
I have read it.
Which was that line?
I have read it. I just.
Expiry after
I
expiry.
have said that there was no relaxation. I have said in the petition.
So relaxation, you are building that argument, Mr. Bhattacharya, with support of some element.
Yes. Kindly come to Milord the writ petition pleading.
Yes.
I just read out that there was.
Let Mr. Das to check it up.
Yes, let's proceed. Now, what is the difference? I again say it's a pure question of law. On that date, whether the relaxation was available. What is the defense of state or the authority that there was a subsequent amendment of law? I take your lordship to that.
Mr. Bhattacharya, suppose this relaxation was not there.
Then many could have not applied, considered at all.
Relaxation is not there. Then the 6.3 provision does not come. That is 6.3 says that you don't have the required training. You have to complete it after appointment within the specified time. 6.3 does not mean assailed in the.
No, that 60 in deepest of respect.
Correct.
Kindly come to 6.3.
Yes, page 130.
The paragraph 9 and 9.
No, so but the first thing will answer the paragraph 9 and 19. You have said there was no relaxation.
26 September says, advertisement says, that is in terms of the 2nd of March rules. 2nd of March rule says that if anybody is without this training, you has to complete it within 3.
I'll explain that. It's not the correct.
This thing goes.
Everything goes.
এই রুলটা রিল্যাক্স পিরিয়ডের মধ্যে কিন্তু নোটিফিকেশনটা হচ্ছে রিল্যাক্স পিরিয়ড এলাস হওয়ার পরে সেটা বলে দিচ্ছে 2nd মার্চ হয়েছে 31শে মার্চ পর্যন্ত রিল্যাক্সেশন ছিল রুলটা ক্লেম হয়েছে রিল্যাক্স পিরিয়ডে কিন্তু নোটিফিকেশনটা হচ্ছে আফটার এক্সপায়ারিং দ্য রিল্যাক্সেশন
Whether the one expansion which comes as reasonable that when 2016 rules was enacted. এটা কোথায় আছে দেখো
এই 26 এর রুলস সেম ডিনি পেজ নাম্বার 111 পেজ নাম্বার 111
ultimately satisfied.
Paragraph 9.
No, paragraph 9 is pleading. That's the clear pleading.
119.
111, that's the 2016 recruitment rules.
Yes.
Kindly see, the rule was published on 2nd of March 2016.
After the relaxation according to you was what?
The rule, when the rule was made, then relaxation was available.
Yes, yes.
And that's why 6.3 was incorporated. Now kindly read 6.3.
So your contention is that after the publication of which this relaxation was no longer there.
Yes, on the date of notification. Issue is, when you are inviting application, then there was no relaxation, valid relaxation. 6.3, which is troubling, my lord, wouldn't have troubled had this notification, my lord, and completion of recruitment process done within the period of 31st of March or 31st April, 31st March 2016. 2nd March 2016 is within the period of valid relaxation. That's why 6.3 says,
So your contention is on the date of advertisement, relaxation was not subsisting.
it's not subsisting. Therefore, the relaxed candidate wouldn't have been at all allowed to without participate at all. Now, money. But I am, one thing, Lord, when your lordship is considering the question of public employment, my lord, this is not a one-to-one issue. This is issue of Lord, whole recruitment process being conducted, Lord, following the principles. Now, here, lordship will kindly, what the state government's Lord stand is, as I understand, Lord, from my juniors, that there was an amendment of law in 2017. Kindly takes up that amendment. This is a part of that I'm told compilation by one of my learned friends.
এই বইয়ে অ্যামেন্ডমেন্টটা আছে, অসুবিধা হলো তোমার আরেকটা বই নেই। তোমাদের কারোর কাছে রাজ্য একটা বই আছে অসুবিধা?
This is very important, amendment of law, which is the probable defense of state.
এটার থেকে পর্যন্ত এই জিনিসটাই কোর্টে দেওয়া আছে, অন্য একজন কাউন্সিল দিয়েছিল, সেটা বলে
কোথায় আছে?
সাগর বন্দ্যোপাধ্যায় ঠাকুরদা দিয়েছিল, পেজ নম্বর ওটা দেওয়া।
But I'm told this is a part of the compilation filed by Mr. Shagor Bandyopadhyay.
23 was argued.
Not 23.
Kindly come to 2017 amendment of the Act.
কে আছে?
এই কম্পাইলেশনের মধ্যে আছে দিনদাস।
আরে কম্পাইলেশন থেকে বলি, কম্পাইলেশন তো দেখি
জর্জ সাহেবরা কম্পাইলেশন থেকে সুবিধা হবে।
So it is there with us.
Kindly, may I just place it, or should we immediately get it?
It is section 23.
No. This is the amendment of Right to Children Pre-Education Act.
Section 23 provides.
Which paragraph?
That it shall be deemed to have gone into effect on the first day of April 2015. That is the retrospective effect given. In 2017 law is made. Retrospectivity is from first of day of April 2015, not beyond that. But I am reading, kindly come to section 1 of the amended act.
অরিজিনাল একটা প্রিন্ট করা।
তাহলে কেন ওটা দিলে? যশোর যে বুঝতে
বলছি এটা বের করছো
না,
আমি সেটাই তো আপনাকে বলছি স্যার।
ওটা কম্পাইলেশন বার করে
এটা হার্ড করতে
What you are saying, Mr. Das?
Well, that book will not really reflect that. But may I read out for your lordship? কোনটা দেবো? এটা মার্ক করা দিলে করো না।
এখানে সাবলীলার কোনো
আগরতলা যে একটা কম্পাইলেশন দিয়েছিল, যে কম্পাইলেশনটা দিয়েছিলেন,
So already keep this as your next argument.
yes, Ranjan, keep the point.
You have already mentioned to us that on the date of the advertisement there was no relaxation.
No relaxation, but the different state, that's why I'm pointing this.
So
State government will not, the appellant rather, have argued, I am told, that this defect was removed because of the subsequent amendment. I want to show that defect was not removed by subsequent amendment. দেখি, এটা দিয়ে তো জজের শেয়ার করি, এটা একটু দেবেন। আরে ওই অ্যামেন্ডমেন্ট এবার কাইন্ডলি amendment brought on 9th of August 2017. But it shall be deemed to have come into force on the first day of April 2015. But therefore, the act was given retrospective effect vis-a-vis 1st April 2015, not beyond that. And then it says, provided further that every teacher appointed or in position as on 21st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children Free and Compulsory Education Amendment Act 2017. There were the persons who were in a position on 31st March 2015. That is the retrospectivity. Here the notification is without June 26th of September, sorry, not June. September 26th. There were the persons who were not qualified, they were not in a position as on 31st March 2015. If they were appointed, then they have to acquire qualification within 4 years.
শেষ প্যারাগ্রাফে বলা আছে ইভেন যাদের রিল্যাক্স দেওয়া হয়েছিল ওই টাইমের মধ্যে তাদের 2 বছরের মধ্যে ট্রেনিং পাওয়া হবে। এই তো এই পেজ নাম্বার 99 ভলিউম 1
Come to me that the original relaxation given at page 99.
this is 99.
Yes. But this was a notification by which relaxation was granted, and my lord will take the trouble to come to clause 7 and subclause Roman 6. State government got it.
Page 99.
9.
It is a part of the.
Yes, but this is the, I am referring to the clause 7.
Of a notification.
Yes.
First April 2020.
Right. This is the first way with Right to Education Act describes qualification.
Yes, what your argument?
May I kindly come to the Roman 6 of clause 7.
6 years.
The state government and other school management shall ensure that teachers who are appointed under relaxed qualification norms acquire the minimum qualifications specified in NCT notification within the period of 2 years from the year of appointment. This relates to the persons who were appointed by virtue of relaxed qualification. They were mandatorily required to earn the qualification. This is before. I'm just saying, therefore, relaxations are always for a particular period to ensure that the people may come up with their training qualification.
Then what happens to Rule 6? Then what
Rule 6 becomes
there was no such
Rule 6 becomes redundant. No prayer is called for. The notification, when the notification is at a point of time,
so you are now challenging also. Having participated, you are now challenging.
I am not challenging, I am not explaining the effect of rules.
Then it is a redundant provision according to me.
According to me, the notification was issued at a point of time when their relaxation was not available. Rule was made at a point of time when relaxations were available. I am trying to interpret the law in the context of the relaxation granted by the central agency. My Lord will read Suks 3 at a point of time when the rule was promulgated, when relaxation was valid. They ought to have completed or ought to have invited the application within the validity period, which they did not or could not. When you publish the notice, then there is no provision for relaxation. Therefore, Rule 6.3 automatically becomes non-applicable.
Sound was not there in the
Yes, it was. It was. Kindly come to Milord, paragraph 9. Where I have started saying, Milord, this is a constitutional code, this is not, Milord, civil dispute between two parties. Milord, kindly come to paragraph 9, I am reading out. Well, I have placed it.
Is when the advertisement was published, when the rule was published in March, that was in March, 2nd March 2016.
Then the relaxation period was valid till 31st of March 2016, sorry. They could have immediately invited application.
Validity was there because it is within 31st.
Yes.
At the time of advertisement, there was no validity.
No validity. That's correct.
As such, 6.3 becomes redundant.
It's not applicable, except with that notification. I can't say redundant. If that was issued within the period, it was valid.
এখন ওই রুলেই হচ্ছে কিন্তু ওটা
Now, my Lord was putting me whether there was any pleading. Yes, kindly come to me, Lord.
Paragraph 9, no relaxation.
9 and 19.
9 and 19 both.
Yes.
And this was never dealt with in the affidavit subject to correction.
No, not deal.
Now, these are the foundational facts. I don't trouble you lot anymore with facts. And I have not based the affidavit filed by the agency. Now, the agency says, what could you get?
Yes.
The agency says that aptitude tests and other things were done by TPSCs at the district level. That's their affidavit. Was any legal existence of DPSC then? Now, kindly see the constitution of DPSC.
আপনারা পারবেন page 31.
On the date of the second type of access that was going
Kindly come to me, Lord. Chapter 6 of the Primary Education Act 1973. দর্শকদের দাও এটা লেটেস্ট তো
হ্যাঁ একদম
Kindly come to that section 37, the primary school councils. District primary school council, state government shall, by notification established for each district, including the hill areas and the areas included in Calcutta, with effect from such date that may be specified in the notification, a district primary school council bearing the name of the district and for the subdivision so and so. Provided the state government shall by notification establish for the subdivision of Shiliguri, I am not troubling my lord, then a district primary school council shall consist of the following members. But all these categories are mentioned. On that date, none of these categories representation was there. What was there? Kindly come to subclause K, chairman to be appointed by the state government. Now the chairman to be appointed in a council. The chairman cannot be bereft of any council. But I didn't read the K, 2K. At the top also the chairman who shall be appointed by the state government. Now everything was done, chairman as persona. And that the existence of the primary school council was not there, has been held by this court just a few days back, and a single judgment having persuasive value. দুটো কপি তো রশিদকে of the judgment, the detailed constitution and the methodology. Then kindly count paragraph 28. This was the case of Purva Midnapur, but the similar for all districts. But I am told Midnapur and Hooghly judgment also there. The records reveal that the district primary school council Purva Midnapur was last constituted pursuant to notification dated 21st February 2011. Its statutory tenure of 4 years expired in 2015. But no election or reconstitution of members has taken place thereafter under section 40 or 41 of the Primary Education Act. Consequently, since 2015, no legally functional council exists in the district. The same judgment will covers for Hooghly, but we have got the report of different districts. My lord, may not be jumbled up with documents, but fact remains that none of these primary district school council had been reconstituted after the expiry of 4 years from the first constitution. I think Mr. Shanial Bulat can enlighten if he can show that there were, at least in a particular district, This point may not be applicable for the district, but this is common everywhere. If even the affidavit which says that this is done by the district school council is also travesty of truth. Judgment deemed pleading. Now, I shall cite authorities on few points. I was told that a thorough argument was advanced. How could the learned judge get these documents under Section 165 of the Evidence Act? Where is corruption? Well, corruption doesn't mean only the exchange of money. Corruption, means the action done in violation of rules to favor persons. That is also corruption. Now, while your lordship will be going to that, নোটটা ছিল মানে ইমপ্লয়েড হতে এভিডেন্স সরি But I will place this in detail, a little detail, not in exhaustive. It's a huge book.
Before you go to that, there was an amendment ruling that every district primary school council it has to be published. That amendment
centrally. Now it was amended saying it centrally it will be done. But this is not the point. They say the aptitude test and everything was done district-wise. In the affidavit. I'll just press it. Therefore, district-wise by the district councils. The center doesn't say, it says we don't have any record. We don't have any record of districts. We have only a list of the
has conducted its selection. That was the amendment.
Centrally selection, now instead of the councils, the board centrally would do. There is no quarrel with that.
Then that means that there will be no district-wise interview. So,
I'll come to the affidavit.
any application was made for district-wise appearance.
Kindly come to their own affidavit.
Concept lower.
The amendment is
that there is no existence of DPSC.
No.
Because you see this is and forget about the amendment. If the board has taken over, that means, does it mean board has taken over means all the interview the district-wise will go?
Well, the board says If the board has taken over, it should be done by the board. Kindly come to the amendment. School could amend. Rules come and amend for primary
2016 rules
I just kindly come to the amendment
page 111.
What is your interpretation of that?
kindly takes up this.
Yes.
কমিটি করলো সিলেকশনের জন্য, কিন্তু অ্যাপয়েন্টমেন্ট দেওয়ার কথা হলো ডিপিএস, সেখানে ডিপিএস
কোথায় সেটা কোথায়? Will kindly turn to the 2016 rules at page 111. Yes.
Sorry, we give back to us.
No. It's very important. I should have pointed out. I missed it. Amendment
এইটাই অ্যামেন্ডমেন্ট রুল। 2016 রিক্রুটমেন্টের পরে 23 সেপ্টেম্বর একটা অ্যামেন্ডমেন্ট হয়েছে, দ্যাট ইজ দিস 23 সেপ্টেম্বর।
এই অ্যামেন্ডমেন্টটা দাও, কোন পেজে আছে?
ওটাকে আলাদা করে দিয়েছে, ওটা রাখুনটা আলাদা করে
That amendment is of Rule 7.
রুল 7।
Let's kindly come to Rule 7 first. The board shall constitute selection committee within the jurisdiction of the council with the following members. The selection committee shall normally function for a period of 2 years. Now this 7 was amended. Now see what is the amendment sought for. The board shall constitute selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers in primary schools within the jurisdiction of the board. Therefore, the power of council was taken over by the board.
What is your interpretation that then no counseling can be done by no committee can be constituted by respective council?
Cannot be. If the board takes over the entire selection responsibility, selection committee which are sought to be created under unamended section 7 now vanishes. And board says
shall constitute
Yes.
unamended portion. The board shall constitute selection committee.
within jurisdiction of the council.
Just for the part, board will constitute selection committee for the purpose of selection and preparation of such appointed of teachers in transition within the jurisdiction of the board.
Amendment 1.
Yes.
The amendment says the instead of the councils now centrally.
Constitute the selection.
Yes.
But say selection committee, there were separate selection committee for separate districts.
Once again, the board shall constitute the selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. Selection, preparation of panel is the duty of the board. In the affidavit, board say that the aptitude tests were done by district councils at the district quarter. I just place it once again. But this really goes against their own rules. Just once again I place it. Kindly come to 375. Paragraph 12.
এখানে ওরা বলছে চ্যানেল কে পাবলিশ করতে ওই
I say that, paragraph 12, I say that 2016 recruitment process was a district-wise selection.
Their affidavit you have shown.
Yes, 375, paragraph 12. একটু দেখাই তারপর দেখা রাখি।
Yes.
আর আপনি ডান থেকে তাকাচ্ছেন না, শুধু বাম দিকে তাকাচ্ছেন। বেশি প্রিপেয়ার আছেন। আপনার সংখ্যা তো কিছু দুষ্ট।
ওকে কিছু না আপনি I say that 2016 recruitment process was a district-wise selection based on the opted district of the applicant candidate.
Where is that vote was that selection committee was done by the council?
What is that? I'm searching for that. This is the affidavit of the primary board. They say, I say that 2016 recruitment process was a district-wise selection, not centrally.
What was your reply to that? In the affidavit in reply?
But even if I did not reply, I accept this. I don't have to go file any reply to that. I say that 2016, kindly read with me.
That was not within the contemplation of these persons. Then suppose the hearing is taken up after 5 years. A person can argue that you should interpret my pleading as a deemed pleading, construed to have included the challenge which I am arguing.
Because what I am arguing is law. My lord, I am advancing before my lord the stand of a statutory authority.
They say that it was district-wide selection based on the opted district.
Kindly read.
Yes. District-wise. Your contention is that this should be construed to be meaning that the council, individual council constituted the interview boards.
No, I didn't say that, Lord. I am mistaken. The board has, by virtue of amendment of law, the selection is now conducted by the board. Now, the board in his affidavit says, the challenge was why not the aptitude test was taken. Then the answer board says, I say that 2016 recruitment process was a district-wise selection, not central selection. Based on the opted district of the applicant candidate, the interview vivacity aptitude test was conducted at the centers under the respective district primary school councils, and there is as such no distinctive record which is kept and maintained in such recruitment process. But if it is the central duty of a board to do it, they should have maintained the records. It is not left up to the districts. But when my lord is considering the public employment and maybe at the risk of deputation, lordship will kindly forget about the beneficiaries. My lord will be pleased to consider the action of the statutory authorities. Because if the action of the statutory authority goes, that the beneficiaries have no role to play.
নাম্বার 518 ওরা এটার 155 স্টেটমেন্টে ওরা বলেছিল পাবলিক ডিসপ্লেতে বল দিয়েছে পেজ নাম্বার 518 পেজ নাম্বার 518 এর পাশে আপনার কার্ড বলতে পারেন
This affidavit of the board would be corroborated from, kindly turn to page 518.
Please come to your reply first. Your reply is at page 391, paragraph 11.
Yes, 391. It is Odir affidavit. 391 Lord is there.
It's 391 paragraph.
Yeah. 391. This is the opposition by board, not my reply. But this is
You showed us page 75 paragraph.
yes. This is the affidavit of board.
Yes. Now this reply to this.
No, this is not reply. That's another affidavit by board.
Yes. You have not given any reply.
No. Because I have placed before your lordship below the 3 consecutive affidavit by the board. I am relying on that. Yes.
Page 403.
Kindly come to Milord at 403, yes.
28 April 2023. 28 April 2023 is second debit. The first one was 24 January. Page 363 it starts. Now, filed by this affirmed.
No, my reply is at 403. Milord, may I place in detail? I did not place it because Milord, my reply does not Milord, really create any case. I have to Milord, depend on the affidavit of the state authorities. But still, then my lord is asking, I am reading it.
This year affidavit, Mr. Vadaji.
But this,
Affirmed on 28th April.
yes. This is dealing with Partha Karmuka's affidavit, the third affidavit of board.
403, my lord, the petitioner filed reply.
Yes, yes.
My
So
lord,
Partha Karmuka, third affidavit.
in opposition filed by the my lord, Dr. Partha Karmukar. My lord, your lordship, kindly see page 400. Kindly see page 400. Affirmation section, the original portion. So
That is the reply or to Partha Karmuka.
that is the date of affirmation, 20th day of April. But by mistakenly, my lord, 403, it is written 28th April. It should be my lord 28th.
20th April 2022. They are writing 23.
Wrongly, my lord, here is wrongly, my lord. They have done, my lord,
They affirmed on 28th of April 2023. Now kindly come to the reply. But a subparagraph A, on 7th of February 2023, the writ petition was taken up along with other 4 matters, and His Honorable Court was pleased to direct the board to come up with the breakup marks of last 10 panel candidates, district-wise, category-wise, minimum-wise, caste-wise.
We only want to see what you said about that statement.
Which statement will that?
That district-wise, which you pointed out, paragraph at page 375.
Will kindly come to me, Lord. 7. I deny and dispute the statements by the so and so. Admittedly, the petitioners did not ask for setting aside the recruitment of all candidates. It's the pair the petitioner to set aside the recruitment process, but after publication of this by the board, it is clear that law was not followed.
Paragraph 12, you have dealt with in paragraph 9.
Paragraph 9 will deals with paragraph 7, 8, 9, 10, 11, 12. My lord will kindly read the affidavit and reply all pleadings, Lord, in its entirety. Otherwise, your lordship would not be in a position to really reach to the truth, which is the role of the court. Kindly come to me, Lord. May I just read it? The petitioners did not speak about aptitude test in the writ petition as they are sure about the fact that no aptitude test was ever taken up. After publication of the merit list, they came to know that marks were given in aptitude test, and accordingly, documents were filed to show that illegalities were committed in aptitude test, and that was never taken up. Recently, the Honorable Division Bench of this court passed one order directing the board to give 6 marks to all candidates. It's something else. Then kindly come to me on paragraph 9. The board is trying to confuse the Honorable Court. In 2016 recruitment process, no district-wise, category-wise, medium-wise, caste-wise data was published by the board. Untrained candidates were appointed and strangely less meritorious candidates were selected by depriving the petitioners. The documents submitted by the petitioners during argument prove the facts. The board did not follow their own rules. And one absolute faulty merit list was published just to cover up the wrong done by them. The petitioner stated that 2020 recruitment is not our headache. Then kindly come to paragraph 11.
Selection committee vote করবে কিন্তু সিভিল it is the DPSC rules.
Ultimately, paragraph 4.
Yes, I said faulty merit list.
Faulty merit list was not published.
But when we come to know that somebody below the merit ranking got appointment, then we say faulty merit list. My lord will consider the candidate. He is not supposed to know all the facts in details. He comes before the court, makes an allegation that this is a public employment, therefore this merit jumping has been conducted. Well, I have given a list, I shall give a list, which are part of the record. If one merit jumping would have cause for inquiry.
Relying upon supplementary evidence.
No, not supplementary. Without the merit jumping, without list which has been mentioned in the can, which has been admitted by your lordship. My lord was pleased to allow me lord some can to be admitted, and in other cases let them argue if they want to argue. From that lord, I have prepared a chart showing merit jumping. Yes. I have just given the detail. Lordship will get details also. I have mentioned everything. এর মধ্যে মারামারি করো না, করতে করতে যাবে।
আর এটা পাঠিয়েছি, মেলে পাঠিয়েছি।
These lists have been handed over to the board.
আরে একটা মেলে পাঠিয়ে না, মেলে পাঠানো হয়েছে।
List of merit jumping. This is part of can which has been admitted by your lordship. I've given the detail.
Can 2 and 3. Can 2 and 3.
Judgments kindly come back.
Yes.
Anything added, Mr. Dasgupta, don't worry. If you both of you disturb him, it will be difficult according to our.
Appointing authority.
That's how.
2006, volume 6, SCC, 4.
94. Vice line act.
Come to paragraph 49 onwards.
Page number 804. 804. 804 দেখো ওটা না, এটা এই মানে 804 বলে দাও।
ওটা
কাট বলে ক্লাসের ছোটটা ওটা লাস্ট ভলিউম 10 ছোটটা।
But that was a case to financial authorities.
Serial number, which one?
Serial number 21.
20. Yes.
Now, kindly 46, 47 deals with the facts little. I am not troubling my lot with that. First. And it may be true. First. But I got it.
Yes.
The relevant point.
I বলছি যখন আমি প্লেস করবো সব বলবো। We'll kindly come to paragraph 44. In the absence of proper explanation, it was not open to the special court to make inferences or assumptions with regard to terms used in the documents. For example, SCB security ledger in relation to the suit bonds, which pertains to the sale and purchase of the suit bonds with different counterparties. This document as such does not contain the description portfolio. Got it?
44
Yes. Give a little bit of factual background.
Yes.
Let me read it once again. In the absence of proper explanation, it was not open to the special court to make inferences or assumptions with regard to terms used in the documents. For example, SCB's securities ledger in relation to the suit bonds, which pertains to the sale and purchase of the suit bonds with different counterparties. This document as such does not contain the description portfolio, but the said appellation has been given to it by the special court on its own. The special court has observed thereupon, therefore all such transactions were entered into by the bank on behalf of HPD. Therefore, they were transactions of HPD. This is amply illustrated by Exhibit 11. A portfolio represents stock held by SCB on behalf of HPD. HPD was entitled to enter into buy transactions and sale transactions with respect to securities coming under that portfolio. The portfolio was built up by SCB by purchasing securities at the instance of HPD. This is also called as building up a position. The suit contract comes under Exhibit 11. By the suit contract, the LOA come within portfolio of HPD. He was allowed to deal with LOA under the portfolio. We are afraid that this inference is not readily available expressly from the document, nor was there any other evidence given by any witness explaining the document suggesting it. Then Lordship may skip over, kindly come to 48. While it may be true that special court has been given a certain amount of latitude in the matter of procedure, it surely cannot fly away from the established legal principles while deciding the cases before it. As to what inference arises from a document is always a matter of evidence, unless the document is self-explanatory. We do not think that any of the documents placed on record during the trial were self-explanatory, nor were they explained by any competent witness on either side. In the absence of any such explanation, it was not open to special court to come up with his own explanation and decide the fate of the suit on the basis of his inference based on such assumed explanations. In fact, these inferences run contrary to the oral evidence given by Shuanshu. Then Lordship kindly come to paragraph 40. Learned counsel for CMF also contended the SCB failed to produce relevant documents that would have established what the 15% arrangement was. For this failure, he contended that an adverse inference should be drawn against SCB. For this proposition, he relies on judgments of this court in such and such. This argument is made by learned counsel for SCB, and adverse evidence is a presumption which the court is entitled to draw under Section 114 of Evidence Act, read with illustration G thereto. Mr. Jetmalani contended that the weight of the authorities would show that unless there are some special circumstances making it obligatory for a party to produce evidence, no adverse inference can be drawn unless a party has been called upon to or ordered to produce the evidence and fails to do so. Mr. Jetmalani relies upon such and such. In Hiralal case, this court reiterated the observations of the Privy Council, where the Privy Council laid down the general rule of procedure that instead of relying on the abstract doctrine of onus of proof, a party to the suit, desiring to rely upon certain state of facts, ought not to withhold from the court the written evidence in his possession. In Gopal Krishnaji, the observation was reiterated and it was observed, even if the burden of proof does not lie on a party, the court may draw an adverse inference if he withholds important documents in his possession which can throw light on the facts at issue. It is not, in our opinion, a sound practice for those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession, which could throw light upon the issues in controversy, and to rely upon the abstract doctrine of onus of proof. In so was a situation of a fraudulent litigant basing his case on a falsehood and withholding vital documents. Merely relies on the observation made in Murugam and Gopal Krishna, both of which say that it is not sound practice for those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession. On the other hand, the three authorities on which Mr. Jetmalani relied independently take the view that unless a party is called upon to produce evidence or ordered to do so by the court and fails to do so, no adverse inference can be drawn against such party. Mr. Jetmalani distinguished of the two apparently contradictory lines of authorities by pointing out that in the authorities relied on by Mr. Kapadia, the facts showed that there was a special obligation upon the party concerned to produce the relevant documents even without being called upon or ordered to do so, and that the party had failed to produce them. Further, he pointed out that observations of the Privy Council originating from Murugasam, which have been reiterated in the subsequent cases, including Citibank, would apply only if the party is desiring to rely upon a certain state of facts. He rightly contends that the 15% arrangement was neither any part of SCB's case nor was SCB desiring to rely on the state of facts. In these circumstances, there was no obligation upon SCB to produce any documents to prove the case put forward by CMF. There was no situation in which adverse inference could be drawn against SCB. Finally, Mr. Jetmalani also asked that irrespective of what the parties did, the special court could have, if it was so minded, invoked its power under Section 165 of the Evidence Act and directed production of all documents it considered relevant, instead of relying on adverse inference which was doubtful in circumstances. This is particularly so with regard to the argument of CMF that the computer spreadsheets had not been produced as per para 7 of the written statement of CMF indicates. The CMF was aware of the existence of the such sheets and yet failed to call upon the SCB to produce it or seek an order for production of the code. The whole thrust of the impugned judgment is that the transactions between SCB and the counterparty banks, which were covered by the 15% arrangement, were sham transactions, making HPD the owner of the suit bonds. Where a transaction results in rights and obligations, it can never be treated as a sham transactions. Then, but I am not troubling with Lord Estoppel. Then kindly come to me, Lord. The relevant portion, paragraph 71. Mr. Jetmalani rightly contended that when these admissions were placed on record formally, there was no objection by CMF to these admissions being taken on record, nor was there any challenge by CMF to the ruling given by the special court overruling the framing of the aforesaid two issues. In the circumstances, he submits that it is not open to CMF to raise an objection at this stage. Apart therefrom, Mr. Jetmalani also relied on Order 12, Rule 1 of the Civil Procedure Code to contend that it is open to a party at any time to give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of any other party. This was precisely what happened during the trial. Merely because such a situation arises, the rest of the case does not get affected and has to be tried in accordance with law. In Bhagavati Prasad, while dealing with the argument that it would not be open to a party to sustain a claim on the ground which is entirely new or not pleaded, this court rejected the contention, held that it was a general doctrine which could not be applied irrespective of the facts of the case on hand, and observed thus that I rely on this. Therefore, the pleadings, even it's not there, my lord, if it is appears from the proceedings before the court will definitely, my lord, look into this. Then para 74, with respect of that case, I am not telling, my lord. The point, therefore, my lord, which decides this court is that if something is there, some pleading is there, and parties want to rely upon, there is no problem in doing so. Finally, conclusion, paragraph 97. Finally, it appears that there is not much to choose between the two contending banks, namely SCB and CMA. Both the banks have tarred by the same brush by Jan Gan committee about fudging their accounts. However, it appears to us that the issue of ownership of the suit bonds could not have been decided on any basis other than what legal evidence showed. The situation is somewhat like a game of musical chairs. The one which is sitting on the chair when the music stops wins. Similarly, the situation before us. Once we eliminate the conjectural findings, we find that all the material evidence on record shows that SCB had purchased the suit bonds from NPCL by paying good money. The original LOA of purchasing suit bonds along with the transfer deed was handed over to SCB. As to how it went out of his possession, it appears to be subject matter of the FIR filed by the SCB so. It is pilfered or misappropriation by some officer in conspiracy with HPD, but that is a matter which will be tried by an appropriate criminal court. Turning to other side, claims, I am not placing that, that's not important. The consideration was that it is not always necessary that you have to plead everything positively, but it appears to court. Evidence letter?
Evidence to 2022 2022 2022
The latest view of the Supreme Court not on evidence is very important. This is 2022, volume 20.
Number 33. The page 233, para 70. Page 233, and my lord comparison, page number 855. Bulletin is
This is paragraph 17 under the heading Purpose of the Evidence Act. You got it? Paragraph 17, 1-7. The purpose of the Evidence Act 1872 is to prove and disprove the existence of facts in issue and to find out the truth of the facts which are asserted by the parties, as the decision of the case lies upon and depends upon the truthfulness of those facts. The Act essentially does the balancing of interest between the parties to the proceedings, and such balancing has to be done by establishing the truth of the facts asserted. Ultimately, the Evidence Act is about the quest towards truthfulness. procedure is the handmaid of justice and not its mistress. That is, procedure is not to control justice, but procedure is the helping hand of justice and it helps to facilitate justice. It is well established dictum of the Evidence Act that misplacing the burden of proof vitiates the judgment. At the same time, the rule relating to the burden of proof is based upon certain practical considerations of convenience and reasonableness and also of policy. But where there is a rebuttable presumption of law in favor of one party, the burden of rebutting it lies upon the latter. At the same time, when any fact is specially within the knowledge of a party, the burden of proving it lies upon that party. But I am an individual fighting against the authorities, and authorities are in possession of all documents. The term especially means facts which are preeminently or exceptionally within the knowledge of a person. It is true that it cannot apply when the fact is such as to be capable of being known also by persons other than the party. This rule is an exception to the rule of burden of proof. Thus, when a person acts with some intention other than that which the character and circumstances of the act suggest, the burden of proving the intention is upon him. The bottom line of the purpose of the Evidence Act is to adopt a procedure that helps to facilitate justice. And ultimately, what is required is to unearth the truth to prevail. That this is the provision of law so far the Evidence Act and pleadings are concerned. Here, the sufficient pleadings are there to show that there has been huge irregularities and scam so far the selection of 2016 is concerned. Now, I have referred in my pleading that there has been a CBI inquiry. I would place the record, the charge sheet filed by the it cannot be shut, not to look into it. No date. Charge sheet filed by CBI in jurisdictional court. In connection with 2016 selection, this selection which is now being considered by the Lordship and now they want to shut the court. Yes, you are shutting the court. Let us go through it.
That can 22
in my petition of say, no question of affidavit.
When was it done?
Recently, 2-3 days back. This is 2-3 days back. The investigation started then. The court, I again will say the constitutional court cannot be put to a closure of not looking the relevant documents when the allegation is of scam.
Your other side and hearing on the next
date.
And other things.
No, therefore, no, other side is able to do. Next, kalke shunben it, pore din. No.
It is a charge sheet which has been filed. It is not a document out from the pocket of the very person. And so he will not advance his arguments today on that.
Next.
We are giving you a copy. We have not informed the state.
একদম টাইপ করা কখন সেটা
Since 2016,
why are they scared of looking at the documents?
This charge sheet is pertaining to which
2016 date, primary recruitment. 2016 primary recruitment. All authorities are under custody.
অর্ডারে সেটা হয়েছে কোর্ট
or not taking that your copy, then you advance your argument.
No problem. Apply, but they have the copy because they are in the group of the accused.
বোর্ডকে একটা কপি দিয়ে দিচ্ছি না এখন দেবো না এখন দেবো না
একটা সফট কপি প্রত্যেককে পাঠিয়ে
একদম বলা
আরে পাঠিয়ে তো এখন শুনছেন জাজমেন্টের লিস্টে কোথায় আমার কপিটা কোথায়
আপনাদের
আরে এখানে জাজমেন্টের কপি নেই তোমার আলাদা করে লিখে
This is a document which shows what is the big UN crime. We are not shutting you out. Let us see because
লিখে
the state
তোমাদের
that
দাও বাইরে
that date. If that is
কোথায়
production of the document to the picture
short the matter.
তোমাদের নিয়ে না কাজ করা হচ্ছে
Whatever you say, I shall hear, but it is a charge sheet. If it is not pertinent to date 20, the date 2014, wasted. You have got many other documents which were restricted by the official ID. We have heard all of you extensively. We cannot shut him down. Let him complete his argument. Allow us to proceed. Mr. Banerjee, Mr. Moyumdar, you're getting an opportunity to come and tell us that. Yes,
Now that I now take to the Shukla, the corruption, the Supreme Court says, তোমার তো আছে বাবা তোমার লোকের তো জেলে আছে ওটা কি এখন দিচ্ছ কেন সফট কপি পাঠিয়ে দিও দেওয়া যাবে দেবে তোকে সলভ করে দিয়ে দেবে বাইরে থেকে পড়ে এসো যাতে তোমাকে জেনে দিতে তাহলে the Supreme Court not what the Supreme Court says on corruption.
Give them one hard copy. They shall share it.
Yes, if you share it, you get it.
And you send this to all of them.
দিয়ে দাও
Just now,
চার্জেস কপি বাদ দিয়ে অন্য কপি থাকলে দাও না থাকলে পরে দিয়ে দিও
yes,
তাহলে পরে দিয়ে দিচ্ছি
আমি সব কপি তোমাকে এক্ষুনি আর ড্রপ করতে মানে হার্ড কপিটাও একটা আগে
yes.
Now will kindly come to Lord 2013 3 SCC, page 1. আমার বই কোথায়? 2013 3 SCC.
Can we suggest one thing? So far as the judgments which you are referring to, tell us which judgments, we will go to judgments and you will go there.
Lord, I have the
But short,
yes,
what your advantage also.
my lord. Lord, I have given the detail, my lord, in the compilation.
There are
In
how many judgments we will read. If you
at least Lord, 10-12 judgments I have to cite.
just tell us those judgments, we shall read.
If your lordship permits me to cite the recent division the judgment of this court, which was upheld by the Supreme Court in SSC, I think that covers all these judgments.
That has been given to us.
Yes, Lord, we can, Lord, place that the Lord should find all these judgments, Lord.
Entirely do not place. That is a 400-page judgment. It will not be used.
The principles, I will just say the principles.
So what does you give us the citations which on which you will be placing the
Yes, Lord, kindly, charta diyeche.
দেওয়া দেওয়া
There are 3 compilations each, the 3 volumes. Have mercy on us.
তোমাদেরকে
total 23 judgment in 3 volume and the index is there. First volume index is there. That is index. Index
লিস্ট করে আমি জানি না তোমার কাজের সময় কেউ সব
Where are the paragraph numbers?
এতে কিছুই নেই
But we don't have the references. At least let us have a copy. The copy দাও কিছু তো জানি না কি দেখা
Now, I just indicate not what I'll rely upon.
You have already relied upon 2022 volume 20 SCC
Yes.
and 2006 volume 6 S90.
Now, I shall immediately place 2013 3 SCC, page 1.
2013
3 SCC, item 3 of the
Which paragraphs? 92, 93, 95?
No, but I have to check it not while placing.
That is given in violations. Serial number 3.
Yes, kindly turn to below. কি করেছো না? Yes, kindly, my lord, this is very important, my lord. So for the role of
2013 volume 3 SCC 1.
page 1, the corruption and the role of the court and authorities.
You are placing para 90.
Para 92. This is page 218 of the compilation. Compilation কোন volume দিয়েছে ওরা? Index করে দাও যত
Same index first volume page 176 ওটা শুরু হয়েছে paragraph 92 টা 218
So this is unfair. তোমাকে বারবার লিস্ট করে দিলাম তো সেই লিস্ট তুমি কেন এরকম কি এগুলো ডিসিশন জিজ্ঞেস করছি কি বললো যে আমি সব কিছু হাতে রাখবে
Request you summarize your argument what you have submitted before us and give us the judgments which we will take it from Mr. Ram.
I shall indicate, well, not Mr. For those who have not been in a position to do that, I shall.
Summarize your argument.
My argument is very short.
Yes.
That the selection process initiated by a public body has to be above board beyond question. Any infraction would vitiate everything. Otherwise, people will lose confidence in the entire system. And corruption would become a part of machinery which will destroy the democratic process.
Yes.
The court's outlook with regard to the public employments, if it is, even in one or two cases, if it is found that it was in violation of statute, Supreme Court, even after a continuance of 20 years, said, no, you go. Many judgments went up from our court also. I shall refer those judgments. There is no scope for any compassion or sympathy for illegal recruitment. But this is the basic thing. Now, before I conclude today, it's over. I just will rely this judgment, placing below the paragraph 92, then conclude today. Corruption in a civilized society, 92, 92
At page 218.
200
Yes.
But before I start this, the admitted position, the court had to take judicial notice of the fact that there has been criminal investigation related to his recruitment, and in prima facie, the persons have been taken into custody and charge sheet have been filed, which proves the corruption. And that's the criminal part of it. When it comes to the question of constitutional court's intervention, then we'll learn the basic principle of Article 1416.
What is the date 2014 was included within that, or it was party
2016 recruitment.
2016.
That's a date and 2016 to include.
No, but I would stand correct after facing
Party is 26 September 2016 advertisement.
rights. And
19.
corruption in a civilized society is a disease like cancer, which if not detected in time is sure to spread its malignance among the polity of the country, leading to disastrous consequences. Therefore, it is often described as royal thievery. Corruption is opposed to democracy and social order, as being not only anti-people, but also due to the fact that it affects the economy of a country and destroys its cultural heritage. It poses a threat to the concept of constitutional governance, which pricks me more, and shakes the very foundation of democracy and the rule of law. It threatens the security of the societies, undermining ethical values and justice, jeopardizing sustainable development. Corruption devalues human rights, chokes development, and corrodes the moral fabric of the society. It causes considerable damage to national economy, national interest, and the image of the country. Now, the basic index of human development is education and health. But if the education is vitiated with any sort of corrupt practice, it really chokes the development of ethical values and sense of justice. আজকে না সবই আজকে হবে নাকি Now, may I stop it today? Next minute I shall just take the other judgment. Conclude.
Was your hearing for the what is it?
Appearance given.
Yes, please.
আমাদের appearance সবাই দিতে
এটা আমার মার্ক করে তোমার কাছে রাখো, দুটো তোমার কাছে রাখো, ওপরে লিখে রাখো বিআরবি করে। This is the list that I would basically the Lordship may take into consideration not, but this is the chart of rank jumping which will appear from the pleadings.
Even to the board.
Because we don't
Yes. But their opposition doesn't matter to me. It has to be opposed by the board.
Yeah, nobody asked for it. No, ওরা চিৎকার করছে, ওরা ইচ্ছা করে।
Well, there are cans for the TET who didn't pass the TET also.
আমাদের কেউ নেই।
No one in our. যদি ওপেন করতে সব ওপেন হয়।
সব ওপেন করে দেয়। হ্যাঁ।
On the next day, we also can come up with
I shall just, I don't know about
three volumes have been given.
the judgments.
You can only
I just indicate below the cases.